on the television, that's fine. Just keep in mind, of where you are on the calendar, that way you can come up on time for when your case is called. Okay? Please rise. The Justices of the Appellate Division, Supreme Court, First Department. Please hear you. All persons having business with the Appellate Division. Draw near, give your attendance, and yet you shall be heard. Please be seated. Good afternoon, lawyers. Welcome to the Appellate Division First Department. Those of you who've been around will know what I'm about to say. Well, maybe not everything. We'll see. We have over 6 hours of oral argument time requested. We have about 21 cases on the calendar. 17 are being argued today. So what I'm asking you is to please ask for the time that you need, not the time that you want. The Yankee game ends at about 10 tonight. I would love to see a few innings if I can. So I would appreciate your cooperation. People versus Maltese. Let me hear from you counsel for Maltese? Yes. Okay, speak up, please. How much time do you ask? We requested 10, we're requesting 5 and 2. 5 and 2. Thank you. 5 and 2, and the people? 5. Okay. I ask you to please keep your voices up so that we can hear you. I know the masks make it difficult, but it's important that we hear each other. Meehan of Huntington versus the State of New York. Appellant, State of New York.
Yes, Your Honor. Appellate request 7 and 1, please.
Do we have a respondent? We don't have a respondent, so.
I'd submit, I suppose.
Okay. Thank you so much.
Thank you.
So submitted. SG Children submitted. 138 Bruckner.
Appellant 10 and 2, Your Honor.
Appellant 138 Bruckner. Okay, I'll give you 6 and 2 and 6. FX Funding versus Fox RX.
Good afternoon, appellant. I request 3 minutes.
Do we have a respondent?
I don't believe so, Your Honor, but I should like.
Okay, I'll give you 3 minutes. People versus the Sean Barcy. There are 2 appeals, not come in. Okay, they both submitted. Both calendar number 2130 and 02005. Anonymous versus anonymous.
Appellant 5 and 2.
Appellant 5, right. I granted argument on this case. So appellant wife is getting 5 minutes and 2 in rebuttal, and the respondent is getting 5, right?
Yes, Your Honor.
Okay, thank you. People versus Harry Persort. Appellant Harry Persort. Am I pronouncing it right? Okay, 4 and 1. And the people? Okay, 4 and 1 and 4. People versus Mulham is submitted. Singh versus New York City Housing Authority. Appellant Housing Authority.
Appellant 3 and 2.
Appellant Housing Authority 3 and 2. Singh.
Respondent
3 and 2 and 3. Larkin versus City of New York.
3.
Appellant Larkin 5 and 2, you say?
Yes, please.
Okay. City of New York.
Respondent 4.
5 and 2 and 4. People versus Gonzalez.
Appellant requests 5 and 2, Your Honor.
People. People versus Joseph. Appellant Joseph 5 and 2. People.
Respondent request 4.
People get 4. Werther versus Werther.
The appellants 5 and 2, please.
5 and 2. Respondent Werther.
Respondent 5.
5 and 2 and 5. People versus Lewis is submitted. Monitronics International versus North Star Alarm.
Appellant 7 and 3.
Appellant 7 and 3. Okay, so why don't we do this? Let's do 5 and 3 on the appellant and 4 for respondent Monitronics. Schnell Contracting versus Empire Outlet appellant. 5 and 2. Respondent.
Respondent requests 7.
Okay. Blake Sanchez. Blake versus Sanchez is submitted. Express Trade Capital versus Horowitz is submitted. Velasquez versus New York City Transit Authority is submitted. First case on the calendar, People versus Alexis Maltese. Do we keep this motion? Yeah. We went through so many variations of this that I lost track of where we are. Counsel?
Good afternoon, Your Honors. May it please the Court. My name is Andrew Steinmetz. I represent the defendant appellant Alexis Maltese. My client, Mr. Maltese, stole a $59 coat from Burlington Coat Factory on December 31st, 2014. He's currently serving a 9-year sentence resulting from a conviction on a first-degree robbery charge. This appeal concerns two fundamental errors in the trial proceedings that produced that conviction. And if I could, Your Honor, I'd like to begin with the first of the two issues that appear in the briefing, which is the lesser included offense issue.
Okay, so give me what the reasonable view of the evidence is that you think required the lesser included offense.
Well, Your Honor, I would point first to the video surveillance evidence, which in many respects is the most critical piece of evidence in the case. And importantly, Your Honor, the standard here, if I could just point you to the standard, which is there only must be a reasonable view of the evidence to support a conclusion that the defendant here convicted the lesser and not the greater of the offenses, and the evidence must be viewed in the light most favorable to the defendant. So here, Your Honor, if the court reviews the video, it will find that...
But it's not just the video, is it? The court credited Morgan's testimony, which basically was, the video is corroboration of Morgan's testimony, right?
So, Your Honor, I think the video corroborates a portion of Mr. Morgan's testimony, but importantly, it does not corroborate the portion of Mr. Morgan's testimony that would bring this incident from a petty larceny into a first-degree robbery. What the video shows is Mr. Maltese briefly raising his arm and bringing it back down to his side.
But Morgan said that that was a knife, right? Well, you couldn't tell from the video what it was, right?
Exactly, Your Honor.
You see him making the gesture, right?
That's correct. And Your Honor, the gesture, I would note, the people maintain that the gesture was a forceful thrusting motion, that it was a stabbing motion. And Your Honor, we submit to you that the gesture, that just does not, that characterization does not square with the review of the video. And it certainly is not...
How about against the testimony of the complainant?
I'm sorry?
The testimony of the complainant, should we ignore that? The jury didn't.
Your Honor, the standard here is about whether there is a reasonable basis for a jury to find otherwise.
Counsel, and part of that reasonableness would include the testimony of the complainant who said that he pulled a knife from his shoe. By the way, a fact that was corroborated during his arrest because the same knife was found in his shoe, right? So there is corroboration.
So, Your Honor, there is corroboration, but the standard here is not about whether there is corroboration. There can be lots of corroboration in the record, but that does not necessarily mean that the court was correct in refusing to submit the lesser included charge. There was also evidence in this record that a reasonable jury could have concluded that Mr. Morgan had reason to embellish, had reason to lie about this defendant. This defendant had been in the store...
Except that everything seems to fit together, right? They found the knife. Although you can't see the knife from the video, finding the knife and the jabbing gesture that's described by Morgan is consistent with a knife, having a knife and attacking, right?
Your Honor, I 100% understand that contention. The issue here is the standard is, and I'm going to point you to People v. Henderson, to warrant a refusal to submit a lesser included charge, every possible hypothesis but guilt of the higher crime must be excluded.
Counsel, what about the proposition that you're not allowed to have impermissive selective dissection? So how can you get to the result you want to get to without impermissibly dissecting Morgan's testimony, which is corroborated, as my colleagues have said, by a lot of other evidence in this case?
Well, Your Honor, I point you to People v. Scarborough at page 371, which describes the situation in which it is permissible for a jury to dissect quote-unquote integrated testimony, or whether testimony is quote-unquote integrated. And here there is contradictory proof in the form of the video and also in the form of prior statements that this defendant made to colleagues.
How is the video contradictory?
So the video
It might not show the knife, but how is it contradictory to the testimony of Morgan?
So after this alleged, and I see I'm out of time, I answer your question very briefly.
Go ahead.
After this alleged incident, what happens is Mr. Morgan very calmly follows the defendant out of the store. He's twirling his lanyard in a casual manner, and a reasonable inference that a jury could draw from that behavior is that is inconsistent with the type of violent felony offense that's alleged here.
Okay, counsel, you got 2 minutes in rebuttal. I noticed that you cited to People versus Anderson and you cited to other cases, but in your brief, you relied a great deal on People versus Jones. So I want to know why that case is not different than the facts here.
Okay.
Okay? People?
Good afternoon. May it please the court. Rachel Bond for the People. So on the lesser included offense issue, the victim here, Johann Morgan, was unequivocal when he testified that he saw a defendant take merchandise, and then when he went to confront him, that defendant pulled out a knife, made jabbing motions at him, and said, "I'm taking the coat." And in fact, during his testimony, the video corroborates it. The prosecutor walked him through the video during his testimony. And in fact, at the end of the video, he says, there, you can see him making that motion. You can't see the knife, but you can see him making the motion. And the People do submit that that is entirely consistent with Morgan's testimony. It corroborates it fully. I would say it corroborates all of Morgan's testimony. And there was no reason to dissect Morgan's testimony here. And Your Honor, if I may, you asked about People versus Jones. And I would submit that those are different from here because in Jones, there was other force used besides that of a knife. I believe that the facts were something about stealing something off of a person and there was some sort of shove or push. And then when the victim went after him, he pulled out a knife. And so in that case, there was a reason that the jury could credit the shove or the push, but not credit the knife. Whereas here, there's no evidence that this defendant simply took a coat and walked out without any sort of confrontation or resistance.
Okay.
In addition to the surveillance video, as Your Honors noted, the knife was found when he was arrested in his boot, the same boot that I believe Morgan had testified to. And it also, there's no reasonable view of the evidence here that he just committed a petty larceny because in the video, he's clearly confronted by Morgan. And there's no reason that a loss prevention agent of a store would confront somebody and then just be, okay, go ahead and take the coat with no resistance whatsoever. There's simply no reasonable view of the evidence of that here. I'd also like to point out that the defendant is actually wrong when he cites that the standard is that every hypothesis possible but that of guilt is required. In fact, in People versus Rivera, the Court of Appeals stated that they had actually gone away from that standard in Scarborough. So that is not the standard. The standard is whether there's a reasonable view of the evidence, and that's simply not the case here.
Counsel, I'd like to address the second issue. How did defense counsel open the door for the admission of the ICAD report? Can you address that?
Yes. So the admission of the ICAD reports, first of all, the court is allowed to bring in, or to allow the people to bring in evidence to rebut an adverse inference, which is what the court was doing here. And additionally, defense counsel opened the door because he was making arguments to the jury that the 911 calls were somehow inconsistent with the testimony that the two loss prevention agents gave at trial, when in fact the Sprint and ICAD reports clearly showed that that was not the case, that they were perfectly consistent. Defense counsel also argued to the jury that the complaining witnesses, the two loss prevention agents, actually colluded, and that the Old Navy loss prevention agent had taken or adopted certain aspects of the Burlington coat factory prevention agent's story. And he also made the point that he wanted to argue what was not in the calls, which I would argue opens the door to what we do know is in the calls. And in that same vein, that makes this case a little bit different than some of the other cases, such as People versus Bullock, which I know defendant tried to distinguish in their reply. However, that was for one, it was a video. Generally, there are not contemporaneous transcriptions of a video when it's made, whereas with a 911 call there is, and they're under a business duty to transcribe that correctly. And additionally, in that case, I believe this court found that the judge had sustained objections to answers about the contents of the video. However, this court also found that even if those hadn't been objected to and sustained, it would have been harmless because the defense had opened the door by bringing in evidence of the contents of those videos. I would argue that we have much of the same situation here.
I'm not sure that's accurate because defense counsel had indicated that the theory of the case was that the complainant was mistaken about what he saw. And then there was a second complainant, it wasn't charged, that since he was at the precinct, that he may have been influenced by the identification. And defense counsel wasn't relying on the fact that there was no mention of the knife in the 911 call. So I don't see how you open the door to that.
Correct. He does not say that he's going to argue that they didn't mention a knife. However, he does clearly say multiple times that he's going to argue that the 911 calls would have contradicted the testimony. And I think that that opens the door to what evidence that the people had about what was said on the calls. Of course, the calls were inadvertently lost, but we did have some evidence of what was said on those calls.
Okay,
Thank you very much.
thank you.
So just briefly, Your Honor, I'd like to address People versus Jones. I think the common thread between this case and People versus Jones, it lies in what the theory that the defense put forward was. The defense was consistent throughout this trial that there is no dispute Mr. Maltese walked out of Burlington Coat Factory wearing a $59 coat that he did not pay for. The defense functionally admitted that this was a petty larceny. That was the theory that the defense put forward, and that was the theory that the defense put forward in People versus Jones. In People versus Scarborough, a case on which the people rely here, the court said, this is the Court of Appeals said, a basis for dissecting the testimony of a witness exists when the defendant, by his own testimony, denies the only ingredient of the criminal transaction, which is a necessary component of the greater crime. And here,
But you agree that, I mean, in People versus Jones, even with an interpreter, the victim couldn't really articulate what actually happened, right? And that's what distinguishes from here. I mean, when you look at the video, when you listen to the testimony or read the testimony of Morgan, it's pretty unequivocal. I mean, he relates exactly what happens. The jury's evaluating that evidence. That's pretty much unequivocal. And that's what I think is different. I mean, putting aside, it may have been a little heavy-handed to charge robbery in the first degree, but that's a different question for another day.
well, but that is exactly the problem here, Your Honor. The jury was left with an all-or-nothing proposition, and that very extremely prejudices the defense here. And if I could mention just very briefly on the opening of the door issue, if the defense had in any way challenged the content of the 911 calls, if the defense had said, Mr. Morgan never mentioned, I see my time is up.
No, you go.
If the defense had said, Mr. Morgan never mentioned a knife on the 911 calls, absolutely that would open the door to the admission of the Sprint reports. But here, Your Honor, that did not happen. The only basis for the admission of the Sprint reports was the acceptance of the adverse inference sanction. And here, if the precedent were any time an adverse inference sanction were imposed, Sprint reports would be admissible on lost 911 calls. That would be a vast change in the law, and there's no precedent for it.
Okay.
Thank you, Your Honor.
Thank you. Thank you both. (138) Bruckner.
May it please the court, my name is Richard Hamburger. I represent the appellant 138 Bruckner. This is a case arising out of a $40 million contract, a sophisticated contract. It's 22 pages long not counting the schedules and exhibits. There were 2 amendments to the contract. It was negotiated between sophisticated parties by sophisticated counsel. There are 2 issues in the case. Is there an ambiguity with regarding the down payment? And was there a basis alleged to support a veil-piercing theory? With regard to the first issue, Justice McShane below found, quote, the word sometimes, quote unquote, in the contract's definition of deposit fairly makes the term susceptible of different interpretation. That was his error. The contract is very clear that there's a phased-in payment of monies on account. First, there's $1 million, which is the initial deposit, and then the purchaser has a due diligence opportunity. At the end of due diligence, if he wants to go forward, he pays an additional $1 million, called the first additional payment. If he doesn't want to go forward, he gets his $1 million back.
But his counterclaim against the is based on the fact that the determination notice was bogus, right? I mean, if that was proven the case, then the buyer would have to put the extra $4 million in, correct? I mean,
No, Your Honor. The events can't change the language of the contract. If the language is clear and unambiguous on its face, the events which caused the second additional deposit of $4 million not to be paid don't change what the contract says. And here, what happened was the friendly reminder notice was, according to the counterclaim, sent. And in response to the friendly reminder notice, the purchaser said, we're not going ahead, we're not paying the additional $4 million because you're in breach. Then they sent a second friendly reminder notice, and after the second friendly reminder notice didn't get anywhere, they sent a notice of default, an opportunity to cure. What was the opportunity to cure? Pay the $4 million.
Not pay, deposit the $4 million.
Deposit the $4 million.
Right.
They didn't deposit the $4
And
million.
I say deposit because that's the language in the contract.
Correct. And the contract would have been inaccurate if it didn't say sometimes.
Right.
Sometimes was very clear because at different points in time, there was a different amount of money that was being retained, another word used in the contract, being retained by the escrow
yeah,
agent.
because in one provision of the contract, it does say the initial and the first deposit would be retained by the seller, right? And that's defined, that term deposit is defined as the $2 million then, right? That's what you're saying. That
The term deposit under the contract is defined specifically as the amount of money that is being held by the escrow agent. The escrow agent might be holding $6 million if the second additional deposit was
I'm
made.
just pointing out the fact that there is a provision in the contract that actually specifically defines deposit as the initial payment and the first deposit, right?
Or
$2 million.
the second deposit, depending upon the point in time when a
Depending
property
on
is
the point in
entitled to be
time,
paid.
right?
Depending on what have been put in the escrow account.
Exactly, exactly. And Judge McShane did not consider Article 16, which makes that perfectly clear, and the law is clear that one has to look at the
Counsel,
entire
your
contract.
position is that it really doesn't matter whether your client breached, your client didn't breach. Under any characterization, the result should stay the same, which is that they just, at the most, get to keep the $2 million.
Correct, because there's a liquidated damages clause that says very specifically in the a seller's remedy.
That was agreed upon by
It
the
was agreed upon by
sophisticated party.
sophisticated parties after careful negotiation on a $40 million contract, which they amended twice. They amended twice. And there's a seller's remedy clause and a buyer's remedy clause, 18A1, 18A2, and 18A3. And the seller's remedy clause is the one that has the liquidated damages, and it says if the purchaser breaches, then the seller can retain, quote unquote, the deposit.
Right.
And the argument
I know they try to punch some holes into the clarity of the word retain.
Correct.
But your argument is
My argument is, I don't know where Justice McShane got sidelined on this because of the word sometimes, but sometimes looking at the entire contract as the court must do to reconcile the entire contract, it's very clear that deposit is defined as what the escrow agent has at the moment when a party is entitled to get what he has on deposit with him. That's why they use the word sometimes. Moving to the second issue in the case, which is the veil-piercing issue, this court has said over and over and over again in the context of motions to dismiss that it is inadequate to simply do, as the seller did here, is to allege in robotic fashion all of the elements of a veil-piercing theory and not to specifically allege what the wrongful conduct is. You can read their counterclaim, and the counterclaim basically alleges, not basically, the counterclaim alleges there was a breach in claiming sellers to be in default.
I'm sorry,
They weren't-
is it a counterclaim or is it a third-party complaint?
Well, I'm sorry, Your Honor, you're correct, Justice Acosta, it's a
Okay.
third-party complaint. They're alleging that there was a breach in claiming the sellers to be in default when they weren't in default. Maybe they were, maybe they weren't, we don't know that yet. There was a breach in not making the second additional deposit, and there was a breach in not closing. That's what the third-party complaint is about. All of those are actions that arise out of the contract. There's
Right.
no independent wrong.
Right.
There's no independent wrong. There's no independent fraud that's alleged. Your Honor, in the Skanska case, which I would love to quote, which you wrote, very similar in terms of the facts, very similar in terms of your conclusions. The parties negotiated this contract, and nobody should rewrite it for them. They're sophisticated parties. If they had wanted individual guarantees, if they had wanted the security of the bond, if they wanted a letter of credit, they could have asked for it. The point was to get that at a negotiating table. They knew exactly who they were dealing with, because in the Second Amendment, there's a specific clause having to do with assignment, in which the identity of the LLC purchaser is revealed as two other LLCs. It's not even in the individual defendants who are named here in the third-party complaint.
Thank you, counsel.
Good afternoon. May it please the court. My name is Lori Saper, and I represent the respondents, defendants, counterclaim plaintiffs, and third-party plaintiffs in this matter. The problem with the appellant's argument is that it completely ignores the fact that this was a pre-answer motion to dismiss. And on a pre-answer motion to
Well,
dismiss—
you only get, the counterclaim only survives if there's a basis for the counterclaim, right? So you have to find something in the contract that actually allows you to go forward with a counterclaim. Even though it's a 3211 motion, if there's no basis for you, you don't have a counterclaim.
Correct, but on a 3211 motion based upon documentary evidence, the contract must conclusively establish a defense.
All right, but counsel,
But-
I'm sorry.
No, I'm sorry.
Go ahead.
I mean, 3211A1, you agree the contract is the documentary evidence, right?
Yes.
So you still, whether it's dismissal motion or summary judgment, you still have to demonstrate ambiguity in the terms, right?
Correct, and
So why
here-
don't we get there?
Yes.
What's ambiguous about deposit?
Well, Section 2.1 defines deposit as the initial deposit, the first additional deposit, and the second additional deposit are hereinafter individually and collectively sometimes referred to as the deposit.
Right.
Okay, it is the respondent's position that Section 18.2 is the relevant damages provision because the
Yeah, but
counterclaim
that
alleges—
18.2, if you read it carefully, says any default by the buyer gives the seller the right to retain the deposit, right?
Correct.
So any default, meaning that could be the $1 million, that could be the second deposit of another $1 million, which makes it $2 million, or that could be $6 million, because depending on where the buyer's default flows,
Yep.
you're either going to get $1 million, $2 million, or $6 million, right? I mean, so that's where it says any default. So that term deposit is a floating. It's dependent on where the default lies,
Well, Your Honor,
because we know that you can't. The escrow agent can only return the deposit that he has. The escrow agent has on deposit, so it can't be $6 million. If it's only $2 million in there, he's only returning $2 million. So
Well,
the term deposit, in the contract, the term deposit is defined, the definition for it, it depends on the circumstances. It's either $1 million, $2 million, or $6 million.
I would respectfully disagree, Your Honor, that in a liquidated damages provision, the whole point of it is that, and it says it right there
I
in
get
the
that,
contract,
but you're trying to say that it should be $6 million.
correct, because that the parties agreed and they negotiated that the amount of the deposit total is reasonable, is a
Where's the
reasonable
enforcement
estimate of the
mechanism in
damage.
18.2 that if they don't put in the $4 million, that you have to put in the $4 million? Where's the enforcement mechanism for that?
18.2 is for any default under the agreement. It
Right.
doesn't
Right, so the
matter-
question is, at what point do you default? Do you default after depositing $1 million, after depositing the additional million or the final 4 million? That's the question, right? And the escrow agent can only give as liquidated damages to your opponent in the context of what he has, right? I mean, because you can only return what you've retained, what you have acquired, right?
Well, Your Honor, the language in this 18.2 is different than the other provisions that the appellant points
But
to.
counsel, isn't the exact language to retain the deposit? So retain the deposit, what meaning can that possibly have other than you retain the deposit that has actually been paid over? It doesn't have any provision to say, and you have to pay over the additional deposits that haven't been paid. It just says retain the deposit. So how is that in any way ambiguous, and how could it mean anything other than retaining the deposit that has actually been paid over?
But it doesn't say that the escrow agent is required to turn over the deposit
No, but it
on
says
hand.
your remedy, if there's a default by the buyer, is to retain the deposit.
The
So
deposit.
how other
The
way could
deposit as a
that be
whole.
construed?
As a whole.
Why? How can you retain money that you don't have? If the default takes place after the second million, you can only disburse what you have retained. That is what you've acquired, what you have with you. The escrow agent cannot return $4 million that have not been deposited, right?
But it doesn't say to return, and it doesn't say.
He says, upon receipt of the deposit shall be held in escrow to be disbursed as provided in section 16 of this agreement. That's the record at page 40. So it tells the escrow agent how to disburse the money. That escrow agent is not going to go into her pocket to disburse more money that has been deposited, right?
That's correct. The escrow agent is not required to pay. The purchaser, based upon its breach and its default under the agreement, is required to pay liquidated damages, which the parties.
Is there any provision in the contract that says that if there's a default after the second $1 million payment, that the buyers are on the hook for the other 4, regardless of whether the contract closes or not?
May I answer, Your Honor?
Yeah, go ahead.
It's our position that it's the definition of the word deposit, which requires, it says sometimes it could be collective and it could be all of them. And in this context.
Depending on what?
Depending on the use in the different provisions.
Right, well, depending on the stage, right? Because these were payments that were being deposited in a staged fashion, right? 1 million, and then 4.
The lower court found that there are 2 different reasonable interpretations at this early stage.
I know what the court found. The question is whether we should, because frankly, from the questioning, you see that we can't quite locate the ambiguity.
Understood, Your Honor.
Thank you. Counsel?
Your Honor, I just want to additionally point out that in the purchaser's remedies, which is the paragraph following the seller's remedies, 18B2, the purchaser, after sophisticated negotiation between sophisticated parties, is given the right not just to liquidated damages, not to a liquidated damages measure, but to actually go after the money that was spent on the due diligence for specific performance, and where specific performance is not an adequate remedy for equitable and
legal
damages relief. So the parties knew how to negotiate that when they wanted to negotiate it, and here they negotiated a liquidated damages clause, which repeatedly references back to deposit. Deposit is sometimes 1 million, sometimes 2 million, sometimes 6 million. There's nothing ambiguous.
So the remedy of specific performance and any other remedy at law or equity is equivalent to the liquidated damages deposits that were being made.
It is the purchaser's remedy, not the seller's remedy. The seller's remedy is what's on deposit with the escrow agent. Thank you, Your Honor.
Got it. Thank you. Thank you both. Did I give X funding 3 minutes?
Yeah.
Yes. FX funding versus Fox RX.
Good afternoon. May it please the court. My name is Harriet Boxer, and I represent the defendant's appellants, that is FoxRx Inc., American Telehealth Network Inc., Dr. Deepak Nandi, a physician board certified in psychiatry.
Counsel, you only got 3 minutes, so let me cut to the chase. Was there a dispositive motion decided by the trial court? Or putting it in a different way, how would us deciding this appeal in the context of whether the court properly decided the discovery issues, how would that affect the right of the parties? Why isn't this moved?
Well, Your Honor, there are 3 reasons. The first reason is that the order ignores the established precedent which construes CPLR 3214B. The order evinces a ruling by the court by edict. For this court to affirm would be to condone such improper adjudication and will act to encourage other orders to flout standing law and or precedent.
How about the fact that the court was obviously frustrated from the fact that the case had been calendared for over 5 years and no discovery had yet taken place? So you have arguments about the court flouting the rules when the parties flouted the rules for years.
Your Honor, respectfully, it's not the defendant's appellants. The
It
plaintiff.
doesn't matter. The case is 5 years old and nothing has been done. At what point does the court say, enough is enough, get on with it?
Well, Your Honor, the fact is that the court ordered a very expedited discovery schedule. And just last
But that was prior to December 2020 when he decided the primary claims in this case, right? I mean, all that's left is the liability of the individual defendants, right?
Right, and the
Whether
court.
they could be liable.
And the court set an expedited discovery schedule, which has now been extended 3 different times. Just last week, the discovery schedule has extended until December 15, 2021. This is on the basis of the plaintiff merely stating, we need more time. The plaintiff has not identified any document that defendants have not.
I mean, we're not gonna, I mean, this court has held that a trial court has very wide and ample Article 31 discretion. We're not gonna micromanage trial courts. So the court allows some discovery to take place, but clearly the court was frustrated with the 5 years that had taken that the case had been pending with no discovery whatsoever. So,
Your Honor, I see my time.
now, yeah, your 3 minutes were off. Usually that's the problem with arguing against yourself, because we don't really, the court understands the frustration of the court. Every judge is required to move their cases and move their calendar. And this court will not micromanage a trial judge's calendar. That's why Article 31 gives her plenty of discretion.
Thank you.
I just want to say that the summary judgment motion before the court took a year to decide that. So when this court is saying that it was 5 years without anything happening, for the first 3 years.
The summary judgment motion without any discovery.
That the plaintiff made, yes.
Okay. Is there a pending appeal of the summary judgment decision?
No, the summary judgment motion found that the 2 corporations breached a certain promissory
Right.
note.
So it's just the individual liability that we're talking about.
Right, and
Okay.
since we've produced 8,000 pages of discovery, the plaintiff has just adjourned on no basis whatsoever. It's prejudice against the defendant's appellants.
Okay.
Thank you very
Thank
much
you.
for your time.
Thank you. Anonymous versus anonymous? Yo entiendo por qué Melissa estaba encojonada.
Yeah.
Good afternoon.
Good afternoon, counsel.
May it please the court. My name is Alan Mantell of the firm of Mantell McDonough Riso, attorneys for the appellant. This case seeks to deprive a wife of 14 years of any share of $400 million of wealth acquired during the marriage. In 34 contracts of film projects entered into during the marriage, 32 new Nobu restaurants.
Isn't that finding based on a prenuptial agreement that was entered into by the parties with counsel? And so regardless of whether it was 500 contracts and $1 trillion, that doesn't matter. The issue is whether the prenup precludes recovery from those assets.
That's correct, Your Honor. And so we're dealing with, this case deals with the defined terms in the agreement of what is separate property and what is marital property as defined in Article 4 of the agreement. Article 4.1a has 5 component parts. Each component part refers to a time frame, either as of the date of the agreement or after the date of the agreement. It's separate property is defined as property as of the date of the prenuptial agreement or as identified on the financial statements annexed to the agreement, detailed financial statements annexed to the agreement. And
So it's property before, it defined property before the effective date of the prenup.
correct, as identified on the financial statement, and also deals in progress identified on the financial statement. Everything else is irrelevant to the issue at hand. And so what we say is separate property is defined by what was existing as of the date of the agreement and
Except that the agreement specifically said and had provisions that if, for instance, property A, pre-marriage, was sold during the marriage and that those funds were then later used to buy something else, that something else was considered separate property.
Yes, exchange of the identified separate property could be separate property, but that would require proof of that. And so this agreement has a detailed provision in Article 6 of annual audits. It also has a provision.
And audits were not done by either party, correct?
I'm sorry?
There were no audits, no real formal audits as envisioned in the prenup by either party.
Well, that's incorrect. That is a finding we say of the lower court. The record contains 3 times that our client sought enforcement of those audits during the marriage. Each time the respondent refused. And there's detailed correspondence from me to the drafter of the agreement, Mark Alcott at Paul Weiss, back in '09. What's particularly important is as soon as that letter was sent to Mr. Alcott, the accountants attempted to do what the agreement said it was attempted to do. Identify premarital income from premarital assets and post-agreement income from post-agreement assets, and that is in the record at page 831.
What in the prenup agreement permitted any income to be included in marital property? As I read it, it seemed to exclude all income.
Well, no, under Article...
So tell me which provision you say does not exclude the husband's income here.
So Article 6C identifies what was intended to overcome commingling argument. It specifically anticipates that all income during the marriage is going to be commingled into the existing entities and into the existing accounts. And to avoid...
And income generated from property that was previously owned, like for example, Nobu.
Or residuals from films that were done before the marriage
Right.
versus residuals and income that was done after the marriage. And those streams of income were identified and kept by the accountants.
I thought all income from all creative work before and after the marriage were excluded.
The agreement doesn't say that. That's what the respondent says. That's what the lower court said. But the agreement...
So where does it say that it is?
Article 6 says you take a look at pre-agreement income and post-agreement income. A designated account each year is to identify pre and post and prepare a ratio of what was earned before the agreement and what was earned after the agreement, and apply that ratio to each new asset during the marriage and give our client a defined right calculated by the designated accountant. Again, the entire agreement, when you look at it as a whole, has a structure of income before and income after. And by saying that all income is his separate property, rewrites the agreement, effectively negates the entire agreement, and basically eliminates the entire agreement. Why have these detailed provisions? Why have a designated accountant identify income? Why identify an intent to overcome commingling? Why go through all of this detailed information if, as you say, all of the income, whenever it was earned, was to be his property? That kind of an agreement could have been easily written. It could have said exactly what you say, Your Honor. And indeed, these people were married before. They had such an agreement. Their earlier agreement did say title controlled. This agreement does not say that title controlled. This agreement requires identity of separate property income, identity of marital income, a designated accountant doing complicated designations and calculations to give each party rights. And the amount...
Thank you. Wrap it up, Mr. Mantel.
Yes, and the amounts involved are substantial, which, again, from our point of view, requires this court to specifically define under the agreement the...
No, I mean, under your definition, she would then be entitled to, or what's at stake, will be 34 films, all the Nobu restaurants, the Nobu Hotel project.
And, Your Honor, since he's never disclosed any of it, that may be the tip of the iceberg. That was ascertained from public sources. He was supposed to disclose every year, every investment, never did it. No one knows. We've never had an opportunity to learn what other assets may be in existence.
Thank you.
Good afternoon, Your Honors. May it please the court, I'm Caroline Kraus. I'm here for the respondent in this case. And my adversary reminds me of the fabulous statement made by the British philosopher Aldous Huxley, who said, "Facts do not cease to exist because they are ignored." And what he is doing is worse than ignoring them.
Seems quite an appropriate.
It seems quite
thing
an
these
appropriate statement. It does, Your Honor, because what Mr. Mantell just argued is based upon a very wild imagination. Article 6 did not require these people to identify income that was earned before the marriage and after the marriage. Article 6 defines Robert's separate property as his earnings.
What is the operative event that Article 6 talks about?
So the operative event is when the marriage is dissolved, right? So
Right.
each year, Mr. De Niro had income from Canal Productions. That entity was a business that was listed on his Schedule A. The provisions of the prenup, Article 4 specifically say that all income from separate property.
Right, so husband is gonna retain his separate property, wife is gonna retain her separate property.
Correct, and she has $1.8 million.
And then we look to the definition of what constitutes separate property.
Correct, and that
How
was.
is the definition as expansive as Justice Cooper suggests, or the language of Article 4 suggests?
Well, so when you look at Article 4 compared to Article 5, Article 5 is very narrow in its definition of marital property. Essentially, it says stuff that's not separate. And what's separate? Separate is everything that he had on the date of the marriage, everything, and it refers to after acquired assets. It specifically says that separate property can be acquired after the date of marriage. Business interests, and income from any artistic or creative work. And so it is hard to fathom how separate property defined as income and profits from any artistic or creative work, coupled with the fact that Mr. De Niro established Canal Productions and his other production companies and Nobu years before their first marriage. So they were married. He had these assets. She was very well aware of how the income was earned. Then they got divorced. They did an agreement. She got money pursuant to that agreement. And then they got married again, and they did a different prenup. And Article 6 was created so that there would be no instance in which commingling was an issue. So if Mr. De Niro took separate property, separate income, and it couldn't be clearer that Robert's separate income is his earnings, that if he contributed that to a marital investment, that he would be able to recoup his separate property investment, and vice versa. There is no obligation, as counsel would suggest, that post-agreement income was to be treated as marital. The agreement, as far as we can...
Let me ask you this. Is there any separate property that is not included in Exhibit A?
So the irony of this, Judge, is that because of the parties' lifestyle costs, and we produced all 15 years of tax returns, because of the way these parties spent money, and Mr. De Niro's accountant submitted an affirmation confirming that he had conversations with them year after year after year, stop spending, not only are the sources of his income, they remain the same, Canal, Nobu, that's pretty much it.
And all those are included in Exhibit A?
Correct, correct. And so it's not only just royalties, it's the income from his artistic work and income from Canal. But
that's subdivision B of Article 4, right?
correct. Because of their spending, he essentially has the same assets today that he had on the date of marriage. And yes, did Nobu appreciate in value? It absolutely did. Did it expand? Absolutely. Is that separate property under the agreement? Absolutely.
And that's subdivision B, the income, rents, and proceeds derived from or accrued upon such party separate property. Then you go to the definition of separate property, and that's included.
And the appreciation and expansion of separate property, irrespective of the cause of it. Mr. De Niro spent every day of his life showing up at the Nobu offices working that business. This agreement protected it as separate property.
Okay. Okay. Thank you.
So again, we have to go back to the agreement.
Let me ask you a question, counsel. If
Yes.
we accepted your interpretation of the agreement, why would they even need a prenup? Wouldn't that be what would happen anyway under the DRL?
Well, the
terms of how the
prenuptial
property would
agreement
be
gives
divided?
Mr. De Niro very substantial rights.
I'm sorry, I didn't hear you because you started talking before I finished my
The
question.
prenup agreement gives Mr. De Niro very substantial rights that he would not otherwise have but for the prenuptial agreement. If you look at 6C,
But so what?
I'm sorry?
So what?
Well,
You negotiated it with counsel, sophisticated counsel.
this was intended to have a partnership arrangement in their second marriage. This was intended to
It
have.
says who, but what was, see,
Well,
the problem is that what's intended is in the P&A itself.
Yes, and so it doesn't say all Nobu restaurants. It lists 13 Nobu restaurants with different capital requirements, different debt requirements, different equity requirements.
But
You said all
Nobu, but the problem you have is that Nobu was included in Exhibit A, and then when you look at Article 4(1)(b), it talks about the income, rents, and proceeds that are derived or accrued from that property that's already identified.
Of separate property, yes, and we concede that any income from existing a separate property is separate property, but not income from property acquired during the marriage. Why does the Exhibit A list only one film if all of the films are to be Mr. De Niro's income? And why does he represent at the end of that quote, "I know of no other deals in progress"? He lists 13 Nobu restaurants and one film project, not 34, not all film projects, not all Nobu properties, not all iterations of Nobu or from, he lists one film project. Why would that happen if the agreement meant all of the income?
But the reason for that is because subdivision 2 of Article 4 talks about income and profits derived from any artistic
Any artistic that goes to
Right, so not
A1
just-
that
not just-
existed as of the date of the agreement or identified on Exhibit A.
I don't think he says that.
Because separate property is in quotation marks. Contract construction clearly means that when you have a defined term, that defined term is identified by A1 through 5. And every time you use separate property thereafter, it refers back to the items in A1 through 5.
Okay.
It does not say all. It does not say every. It says limited A1, and all income from that is separate.
It says any, but
Any-
we'll take a look. We'll take
Any
another look.
from the existing assets or as identified on Exhibit A.
We're obviously going to take another look and deliberate among the 5 judges.
Thank you very much.
Thank you both. People versus Harry Persaud. Porque él es demasiado, sabe demasiado.
Good afternoon. May I proceed? Good afternoon. May I please the court? My name is Nicole Giaglas, and I represent the appellant in this case, Ishri Haraprasad. Rather than being strangers, in this case, Mr. Haraprasad and the complainant were well known to each other. Prior to Mr. Haraprasad...
What about when they met in the park? Did they know each other then? When they met in Mount Morris Park? Let's talk about that. Did they know each other then?
I'm sorry, Your Honor.
Let me start again. You know, it's hard with the math.
Yes.
So you say they have a relationship. I want to take it back to when they first met at Mount Morris Park. They did not know each other. Is that correct? When they first met?
That is correct. When they first met, they did not know each other prior to that time.
And defendant approached him, correct?
Yes.
Appellant approached him.
Yes, according to the complainant's testimony, Mr. Haraprasad approached the complainant.
So that night, they were strangers.
That day, they had just met.
All right. And he had sex with him that day. So he wasn't known to him, he had just met him.
The evidence is not clear and convincing as to whether they had any sexual encounter the same day that they met.
But they were, I'm sorry, go ahead. Yeah. No, they were strangers, right? Isn't that what Factor 7 talks about, right? They were strangers to each other until they met. And the question is, what happened the day that they met?
That is relevant to whether they were strangers, is what happened that day. And the evidence is inconsistent as to what happened that day.
So you're saying if he waits until the next day and has sex with this 13-year-old, that would be okay?
We're not saying that any of the sexual contact between them was okay.
But you're saying that, that they knew each other.
Yes,
This grown man establishes a sexual relationship with a child he just met.
yes.
So
It
how
is not
does that not satisfy factor 7?
because they were not strangers
What's a
during the course
stranger?
of their relationship.
What's a stranger?
A stranger is someone that does not know the other person.
And on the day that he met him in the park, he didn't know him.
On the day that they met, yes, but there is not clear and convincing evidence that they had sexual contact at that time.
Counsel, wasn't it the victim's testimony, though, clear testimony from the victim that they did have sex within 24 hours of meeting each other?
According to an excerpt from the complainant's testimony, yes, but
So
the
there's
PSR...
testimony from the victim that supports that finding, that they had sex within 24 hours of meeting. Isn't that right?
The complainant's testimony does support that, but the case summary and the PSR are not consistent.
So you're
with
saying
that.
we should weigh that and not weigh the testimony of the complainant?
I'm saying that both should be weighed, and because of that inconsistency, the evidence is not clear and convincing. It doesn't meet the heavy
So
burden.
because your client claimed that it took, I don't know how long he says that this relationship went from stranger to best friends. I know him so long.
No, Your Honor, it's not based on
So
statements
how
by
long
Mr.
was
Harrell.
it that your client claims he knew this child before he started having sex with him? That it would not count as a stranger?
The case summary and the PSR indicate that the two became acquaintances
Right.
first.
So your point is, I'm trying to understand it because I didn't get it from your brief. So your point now is you have a case summary and a PSI that are inconsistent with each other, but that are now based on interviews with the victim himself. And the victim himself says what you've already heard from us with respect to whether they had a sexual encounter that day and the nature of their relationship. You're saying that that testimony standing alone, given the inconsistency in the case summary and the PSI, do not rise to clear and convincing evidence, correct?
Yes.
Okay, thank you, counsel. Yeah.
May it please the court, Robert McIver on behalf of the respondent. The SOAR court in this case correctly assessed points for stranger status because the trial testimony proved the defendant and the victim met on the night of the offense. The court correctly understood that the trial testimony outweighed the obvious inaccuracies in the pre-sentence report. I'm happy to address any questions that the court has, but I would simply...
Yeah, you know, I mean, we would not be here, well, maybe we would be here, but there wouldn't be any questions as to whether the victim's testimony alone rises to to clear and convincing evidence if the PSI and the case summary were not inconsistent.
That's correct,
What's
Your Honor.
up with that?
Well, as you noted earlier, that they did not interview, the probation did not interview the witness in this. They noted that they called the house and they couldn't get through. So I think it's easily explained. At the end of the day, the structure of SORA specifically contemplates that the PSR might not be infallible. There are situations...
So the information on the PSR came from whom?
It appeared to come from just summaries of the charging documents, as I understand it, but they certainly never spoke to the victim. They did speak to the defendant, and the defendant denied guilt.
Yeah, see, that's the problem. The problem with that is that these are documents that we generally rely and accredit it because they consider to be reliable. In this case, clearly they're not.
That's correct, Your Honor. I think I characterize them as that they are reliable hearsay until they are demonstrably false. And in this case, the trial testimony established beyond a reasonable doubt that the defendant and the victim had sex in February of 2012. At that point, that outweighed any potential inaccuracies.
So at bottom, you think factor, the 20 points that says based on factor 7, based on the testimony of the victim himself, and that's it, rises to clear and convincing.
Absolutely, Your Honor, if not more.
Okay, thank you.
Thank you.
Siempre la cagan esta gente, man.
In terms of the preparation of the pre-sentence report, it is correct that they did not speak to the complainant in this case, but they would have access to the assistant district attorney who prosecuted the case, the charging documents.
But clearly, the folks that were compiling these reports screwed up, right? They didn't interview the victim, and the victim's testimony is unequivocal. Both with respect to the nature of the relationship and how long they knew each other. So the question is whether those 20 points based on factor 7 were properly assessed, right?
That is the question, whether those points were properly assessed. The complaint, I would also note that it was an excerpt from the complainant's testimony. There's no indication as to what may have been explored on cross or what other evidence may have been available in the record that could have contributed to the pre-sentence report. And I would remind the court how reliable and how heavily pre-sentence reports are relied upon by courts before assuming that this is.
No, indeed, it's very troubling, but the court has to decide it even based on those errors. So thank you both. Singh versus New York City Housing Authority. Oh, these are the guys. Ready?
Good afternoon, Your Honors. May it please the court. My name is Dennis Dozis. I'm from the law firm of Litchfield Cavo. I represent the defendant appellant, New York City Housing Authority. Our arguments are pretty clear, I believe, in our briefs. I appeared today in order to answer any questions that the court may have and to rebut any arguments that the plaintiff may make. I know that with respect to costs, I guess, itemized, delineated arguments with respect to each cost, but I don't want to belabor the court with that. So unless Your Honors have any questions, I'd rest on my papers.
I think we're good. I mean, this is, the difficulty you have is the court has a lot of discretion to run its calendar. You heard me say what I said before. Clearly you caught Justice Suarez on the short end of the stick, so.
I understand that, Your Honor, and respectfully, I would argue that the court below abused that discretion in not running its calendar, but in awarding costs and sanctions against this defendant. I respect everyone who runs their own calendar, even when I'm not running my own and others are running it for me. What the conduct that we engaged in as a firm was to preserve our rights pursuant to the CPLR and the NYCRR to the extent that the court below found them unpersuasive.
You utilized documents to support a motion that had been precluded by an earlier decision. That's wrong every single time, every day of the week.
Your Honor, with all due respect, it wasn't clear from the orders of the court below.
It wasn't clear?
At that point.
What part of the language of that prior order that precluded you was not clear?
We used the affidavits from the witnesses that corroborated testimony that we obtained through non-party depositions.
Yes, and the court precluded them. And then you submitted another motion utilizing the documents that had been precluded. Those very same non-party depositions were precluded, counsel.
And we lost both motions. And there was no prejudice to the plaintiff.
You submitted a motion with documents that were precluded from the court. I still haven't heard from you how that was appropriate.
It was,
And how that would not be more than sufficient basis for a sanction.
Your Honor, we asked the court for direction via our re-argument motion on whether the testimony that we obtained during the pendency of the toll, not testimony that...
Did you tell the court that there was an order precluding you when you asked that question?
Yes, Your Honor, the subject of the re-argument motion was the order precluding from the same order from which we sought an extension of time to comply.
Okay, thank you, Mr. Sosa.
Thank you.
Good afternoon, Your Honors. My name is Paul Maloney for the respondent. The re-argument motion was made to re-argue the denial that Justice Rosado issued when the defendants asked for an extension of time to conduct depositions that she had already precluded. They then went ahead and conducted those depositions. The re-argument motion was filed on November 7th. I'm sorry, the motion for the extension of time was filed on November 7th. The depositions were conducted a month later on December 7th. There is no way that the relief to ask that those motions could be deemed admissible could be in a re-argument motion because it hadn't taken place yet. This law firm violated 3 of Justice Rosado's decisions, point blank, no argument. They then went ahead and attached these illegal transcripts to a motion for summary judgment to a new judge who had not issued those orders, who didn't know about the case and didn't tell him in the original filing of that motion. I don't know what more I need to say.
Thank you, counsel. Okay, thank you both. Larkin versus City of New York. Justice Kern has recused from this case.
Well, with Your Honor's indulgence, I would like to take a sip of water.
Go ahead, counsel.
Thank you. I was particularly careful, having dropped the pitcher twice before in a courtroom.
Okay.
Good afternoon. My name is John DeMaio. I represent the appellant, the plaintiff. The basis of the order of dismissal was based...
Counsel, did you represent the plaintiff in this case in prior criminal proceedings or early on?
No, Judge.
During the course of this case?
I don't recall. Sometimes I do of-counsel work for my friend Regina Darby. I don't believe I was ever on this.
Yeah, because the court is really concerned that, I mean, I understand the argument. I understand the argument that Ms. Darby raises in her reply brief with respect to, I mean, basically with denying this person a day in court, this plaintiff, a day in court.
Yes, Judge.
Because he doesn't have the money to get the transcript or
Correct.
the ability to get the transcript. The problem is that initially in this case, you had 3, 4, 5 stipulations where plaintiff agrees to produce these transcripts. Now, I know how difficult they are to get. Institutional providers get 2, sometimes 3 years to get a transcript of a trial. In this case, you had 3 trials. So clearly the people must have had those transcripts at some point, because usually you don't get to retry a case unless you know what happened the time before, right? So can you explain to me that sequence?
My understanding, based upon the record, which I believe is uncontradicted, is that the plaintiff did not have all of the transcripts, had a portion of the transcripts, provided the transcripts in their possession, and did not have the funds to buy the remaining transcripts. I will
At what
out-
point in time was
I'm sorry,
that?
Judge.
At what point in
I don't
time?
always hear well, Judge.
At what point in time was the court aware that the defendant had some but not all of the transcripts?
My understanding is that was early on, and that was presented to the court on a number of occasions in all of the prior machinations that went on in this case, which were many.
I think Judge Kern actually issued an order that says, turn over the document, and then there was like on the side note in the margin saying, if you have it. I recall reading that.
Yeah, there are many affirmations from
Right.
a colleague indicating that they did not have all the transcripts and provided the ones they had.
Well, the bottom line, the question for me is, you can't have a plaintiff produce documents they don't have, right?
Correct.
I mean, that's one side. He doesn't have it. I only have whatever I put forward in the motion papers to support his case. Here's the other part that I'm reading in the record here. There was always a question as who's going to pay for this, right?
Correct. My client was indigent,
And the city's
city has
asking for
unlimited
these
resources.
documents. The city's asking for these documents, but was there ever an offer that they were going to pay for it?
Never.
Because if that was the case, it would have been fine. I'll go get, the plaintiff would have said, yeah, I'll go get the documents. You're paying for it, fine. I'll go get the documents. But he's got no money. City says, give me the documents. He doesn't have the documents, so where's he going to go at that point, right?
I agree with that, Judge.
Kind of like the dog's just chasing his tail at this point, just going around in circles, right?
Yes, Judge. And also, I think even more importantly, the decision of dismissal claimed that the initial order directing this was a self-executing order. And as is pointed out in the reply brief, there were two subsequent orders, one of which said, city's request for preclusionary language, underlying transcripts, is denied. So it could not have been a self-executing order. No further compliance conference is necessary, although the parties may request to be recalendared at this time. That was the entire order.
See, I still, whether they were self-executing or not, the court is still troubled by the fact that, 8 years went by, and a bunch of stipulations with you agreeing. What I would have expected was someone on behalf of the plaintiff to say, whoa, 3 trials is thousands of pages at 25 cents per page. I don't have that kind of money. Or why doesn't the court counsel, who has the ability to just make a phone call to the DA's office and get the transcripts, why isn't there some negotiation taking place about that, rather than continuing to place stipulations in front of the court to so order them?
Yeah. Well, what I would say is that while there's a long record here, there is no, the dismissal was based exclusively upon what's called the self-executing order, which it was not. And there was no evidence, there's no evidence in the record.
Yeah, but the court below talks a great deal about the failure to comply for more than 8 years.
It did, but that was dictum and not the basis of the decision.
No, but it's not, you can call it whatever you want. It's clearly not the holding of the case. It may be dictum, but the court is frustrated with you because she's saying, there's been 8 years already. You've been agreeing to produce these transcripts, and I don't hear a peep from you about whether you can, your plaintiff, I'm sure, cannot go ahead and pay the thousands of dollars that it will require to obtain these transcripts.
Yeah, the frustration of the trial court was understandable, even though the record is replete with the suggestions to the trial court that we don't have the money. We turned over the ones that we had, but I will point out that the trial court is without power to dismiss for want of prosecution absent a 90-day notice, which was never filed here. So while the trial court also, is my understanding under the CPLR, can issue their own 90-day notice, which they declined to do. So we don't have a self-executing order, which was the only basis for the dismissal. The plaintiff doesn't have the money, no 90-day notice.
Except that the court is not being told. I mean, she's saying, you know, she ordered you to provide the transcript in 2011, and you have failed to comply for more than 8 years.
I understand that,
The court is
Judge.
frustrated. Because
Understandably.
you're not protesting, you just keep agreeing to do it. Not you, I mean.
I understand,
counsel
Judge.
for plaintiff.
I understand. The only other thing that I would point out is that the dismissal has never been reduced to a final judgment. And under the CPLR, the plaintiff would simply have the right to bring on a new case within 6 months and start all over. And I don't think that's at all practical here. I think the only practical result would be to reinstate the action and even perhaps in the decision make a recommendation that the court proceed with some dispatch.
Okay, thank you, counsel. You take care of this guy?
May it please the court, Jeffrey Stannard for the City of New York. It was 10 years ago, over 10 years ago, that the plaintiff was originally ordered to produce these transcripts.
Okay, let me ask you a question, counsel. Right, these are 3 trial transcripts of the criminal prosecution, correct? Criminal trial. So you're asking, the defendant is asking, or at least the stipulations that are signed, that plaintiff will turn over the documents or to turn over these will produce these transcripts, right? My understanding is that when you have well, not too long ago when I was in the trial part, you can't have a plaintiff turn over documents they don't have. So then the next question goes, well, if you want them to turn over documents they don't have, who pays for it?
Well, Your Honor, I want to point out right at the outset that those orders are not the orders that are on appeal today. The order
The order that is appealed today is the motion to vacate the dismissal, correct?
That's correct.
Right, and then what happens is when you got to look at what's the basis for the motion to vacate the dismissal, and what was the dismissal based on, and you kind of peel it back. It's like an onion. You keep peeling it until you start crying.
I'm not sure you necessarily do, because plaintiff...
Counsel, I suggest that you answer the question he asked, because if you don't you're going to answer mine.
To answer Your Honor's question, the CPLR allows discovery on documents that are in a party's possession, custody, or control.
Right.
Control means documents that a party has a practical ability to obtain.
Right.
How does he have a practical ability to obtain transcripts from over 7 years ago, at the time that they were requested?
Because he could seek them the same way that any party can seek.
And the same way you could seek them, through the Corp Counsel.
That's
and the District Attorney's Office.
That's correct, Your Honor.
Who would, as a practical matter, as my PJ said previously, if you do a retrial and a mistrial, you order the transcript of the trial, which means the people of the state of New York have a copy of that transcript. Why did the city not get it from them?
The city was never ordered to produce the transcripts. The plaintiff was the only party.
I understand, because you requested it. But my question to you is, again, the defendant here, the plaintiff here said, I don't have all of the transcripts. Seems to me that under the CPLR, since you're the party seeking the document, right, that if costs are associated with producing it, it is you, the party seeking it, who has to pay for it.
My understanding is that under the Greenpoint case we cited in our brief, actually, the producing party should bear the initial cost of production, and that wasn't preventing plaintiff from
Under
later...
Waltzer versus Tradescape, a First Department 2006 case, each party should shoulder the initial burden of financing his own suit, and based upon such a principle, it is the party seeking discovery of documents who should pay the cost of their reproduction.
That's true, Your Honor. Greenpoint is a 2012 case that found that the party producing the discovery should bear the initial cost, subject to...
If they have it, they don't have it. So we are talking in a vacuum and pretending that the plaintiff had the documents you seek.
Yeah.
I think...
So why should we prevent him from having his day in court when not one, not two, but 3 juries did not find sufficient evidence to convict him?
Because plaintiff did the one thing that he could not do. The one thing he could not do was ignore 4 orders in a row over the course of
No,
4 years.
but that begs the question, counsel, and this is a concern that I have. The concern that I have is the city of New York, and I mean, I was a city commissioner, so I know a little bit about this, but court counsel can very easily obtain the transcript from those mistrials from the district attorney's office. I understand the frustration with a plaintiff that continues to agree to do something that he doesn't have the ability to do. But you have a higher obligation, I think, and this court certainly, I mean, one of our fundamental principles, and you see it reflected in plenty of decisions and during arguments in this court. We want people to have their day in court. I mean, a lot of the corrosive effect that occurs in the context of access to justice is people being denied their ability to be heard by a judge or a jury or whoever. It doesn't mean that they're going to prevail, even in a dispositive motion at trial, but to deny this man the ability to appear before a court and tell his story, no guarantee he wins. He may wind up losing. I don't even know a lot of the underlying facts related to the mistrial. Clearly, a juror bought a lot of the claims that he was making because they clearly did not convict him twice and then let him lose the third time. So my question is, you know, why doesn't court counsel just call the DA's office rather than continue to execute stipulation with a plaintiff that clearly is poor? I mean, he had poor person, he had an institutional provider represent him during the first 2 trials, right? 3 trials. So clearly he has no money. Where is he going to get thousands of dollars to get a transcript, even assuming he has the ability to get them? So to me, I don't want to get into the back and forth of how many stipulations, did he agree? I agree, the court clearly was frustrated that she kept ordering stipulations and they agreed to do something for more than 8 years that they couldn't do. And nobody stood up in that courtroom, whether court counsel or plaintiff, to say, you know, even if we were able to get it, he doesn't have the money to pay for it.
But that was said, and that was ignored.
I see that my time is up. May I briefly respond?
That wasn't a question as much as a statement of frustration with how this developed.
I would just say we don't have the benefit of knowing exactly what was said at those compliance conferences.
True.
It was in the court's discretion to choose to order the plaintiff to produce these, and he was given multiple chances. And at a certain point, while we want to give people their day in court, you know, if you ignore that many court orders, it can be found willful and contumacious.
I agree. Thank you, counsel. Thank you both. Oh, counsel, you got a minute on rebuttal. I'm sorry.
Nothing further.
Can one
Thank
be
you for your
willful and
courtesies.
contumacious
Sorry,
and not?
Judge, I didn't hear.
Can one be willful and contumacious in not providing what one does not have?
It cannot be willful or contumacious if it's not in their possession and they can't afford to get it. It doesn't rise to that level. Willful or contumacious.
So stipulation should have never been put in front of the court to so order when everybody knew that you couldn't afford it and you couldn't procure them.
Law office failure is often recognized by this court. It shouldn't have been done, but I don't think that,
fair enough.
You know, I don't think that the plaintiff should be denied his place in court based upon that. Thank you, Your Honor.
Thank you. Thank you both. People versus Gonzalez.
Okay.
Let me calm down.
Good afternoon, Your Honors. My name is Susan Epstein, and I represent the appellant Lennon Gonzalez. The people failed to prove in this case that the complainant faced a substantial risk of death from his injury, or that his wound resulted in a serious and protracted disfigurement, or that his wound resulted in a protracted impairment of his health.
When he ran, or I forget whether he ran or was taken, he actually walked from 163rd to 165th, which is where the children's hospital emergency room is, right?
Yes, he
So
did.
he goes into the emergency room, and a doctor who's only allowed to treat children decides that he cannot send them another 100 feet to the other emergency room for adults because he thinks that, what did he call it? Is life-threatening.
Right.
And clearly the guy's bleeding out from the cut that the defendant inflicted. So why is that not a serious injury?
Well, Your Honor, it's not serious injury because no measures were taken apart from cleaning the wound and giving antibiotics for the bleeding to stop. The bleeding stopped on its own. He was not sutured until the next day. They left the wound open with just a
They
dressing.
had to because it was a gaping hole.
No, it could
And
have
that
been-
is typically what is done with that kind of a puncture.
Well, the injury was not life-threatening, Your Honor. There were no transfusions given. The bleeding stopped on its own in the emergency room. They left it open, just put something over it so it wouldn't get infected or dirty. And the wound was left open for further testing to take
And
place.
how many stitches did it require?
It required 60 stitches. And you know what? It's a physical injury, but it's not a serious physical injury. His life was not threatened. What might have happened?
Physical injury is satisfied by a punch or a slap, and you are equating a puncture that required 60 stitches
The neck.
in the neck. I
Yes.
mean, he's lucky he didn't catch the jugular vein.
But you know what? What might have happened is not the standard. It's what actually happened. And the second, third, and fourth departments have held that specifically, that possible consequences if the cut had been an inch over and gotten the jugular vein, that's not the standard. It's what actually happened, what the actual injuries were. Here, there was
Putting
no
that aside,
vascular
counsel,
damage.
What about the serious disfigurement problem?
Your Honor, he
How could
had
that not be a serious disfigurement?
He had a scar, 2-inch scar, on the back of his neck, running along his hairline. And I know I hope you've seen the photographs, People's Exhibit 5A and B. The scar is, well, you can see that it's a scar. If you were approaching him, you wouldn't see the scar. You'd have to look at the back right side of his neck to see a scar that directly ran along his hairline. His hair was cut very, very short, and even then the scar was the same color as his skin. It's not the kind of dramatic scar where you have a scar running from the ear to the nose or mouth that other cases have found profoundly disfiguring.
I still just can't get over, and I know I keep going back to Dr. Breckstein's finding that this was a life-threatening injury. I mean, you're talking about a large, very deep, gaping 5-centimeter laceration to the right side of the neck with oozing blood.
In cases where they've found serious physical injury, transfusions have been required. There's the risk of bleeding out and dying. In this case, nothing was done to stop the bleeding. It was given antibiotics, it was cleaned, and a dressing was put on the open wound.
Well, there were multiple foreign bodies in there, right? I assume that
And
since he was with a bottle neck, that there was glass inside, very close to the so several vital bodies.
Yes, Your Honor. The law is very clear that the fact that it was close, but it didn't injure those that could have happened if it had been further over. But I believe this court also has its precedent that is in accord with the second, third, and fourth departments, which have all said that it's not what possibly could have happened, it's what actually happened. And the actual injuries are, it's a terrible looking injury when you look at People's Exhibit 3.
Yes, it cut through two
horrible
major
looking.
muscles.
Well,
That
no,
is
it did
not a light.
There's no evidence that it punctured the major muscles at all, Your Honor. That was Dr. Breckstein's initial assessment, but the medical records contain no evidence that any muscles had to be stitched. And he was
he found the CAT scan showed that the trachea and the esophagus were intact, but it doesn't mean, just the area itself require both suturing inside the wound itself
Yes.
and then working your way up to the skin, right?
Exactly, Your Honor. But they found in the medical records also, apart from no evidence that any muscles were actually injured, that he had full strength to all his muscles when he was discharged. So as
Well, he was discharged, but later, wasn't he complaining of inability to move the neck, you know, not just the ugly scar, but he couldn't put down his neck?
He said if he held his head up too long, he had pain. He also said he had trouble breathing. There was no evidence of any damage to his breathing mechanisms in his body. And there's no records that provide evidence that an impairment that would result in this pain existed. You need to have specific medical records that show, I'm sorry, I see my time is up. The records need to show that there's a link. The medical records need to show a link between the actual injury and the subsequent complaint of impairment. It's not a catch-all provision.
Okay, got you.
Thank you.
Thank you. Let me hear from the people.
Good afternoon, Your Honors. Julia Gorski for the people. It is our position that serious physical injury was well established here. Regarding the substantial risk of death, losing consciousness, going into shock, receiving a blood transfusion, none of those events are necessary to find serious physical injury. As Your Honors have noted, this was a deep, gaping laceration to the victim's neck. It took 2 layers of stitches to close fully. I'm sorry, I'm having trouble hearing.
This was a jury trial, correct?
Correct.
That's what the jury found. I mean, we're here to sort of wonder, look over whether or not the jury missed something, right? I mean, am I missing something, or?
No, Your Honor, we believe that you should give full discretion to the
Right.
jury and that they reach the correct conclusion in this case regarding whether or not serious physical injury was established.
All right, it's a weight of the evidence question here.
I'm sorry, what?
It's a weight of the evidence question that we got to look at, right?
I'm sorry, I can't hear you.
I'm sorry, it's the weight of the evidence question.
Oh, well, the defense frames it as a weight of the evidence issue, but really at its core, it seems like a legal sufficiency issue,
Right.
Which was not preserved, but either way, serious physical injury was established here. If I may, I could also move on to the Rodriguez issue. It's our position that the hearing court properly denied defendant's motion to suppress Francisco's identification testimony because the record thoroughly supported that they were well known to one another. And addressing the excessive sentence claim, given the vicious nature of this attack, we submit that defendant's sentence was fair and appropriate and should not be disturbed on appeal. And if there are no further questions, we ask that you affirm.
I think we're good.
Thank you.
Thank you.
Your Honor, before I depart, I just want to point out that he was given a sentence of 12 years. He could have received a sentence as little as 5 years on the first-degree assault charge. He is a paranoid schizophrenic. This was his first felony conviction. He's currently 44 years old. Prior to this, he had 1 misdemeanor conviction for criminal mischief in the 4th degree.
What did the court, because it seems to me that, I mean, the court expressly considered the significant, and I'm quoting the court, a significant and severe mental health issues in imposing the sentence. So, like,
It would appear from the sentence that was given out that the court was saying, this guy's crazy, and we can't let him out on the streets
Let's give him the
again.
minimum, right? Not 12.
Let's give him 12. He's scary. We don't want him on the streets. However, this court has repeatedly reduced sentences, finding that serious mental illness is a mitigating factor, not an aggravating factor in getting sentenced. The prisons are not a warehouse for the mentally ill. This man needs treatment. He needs to be maintained. He has strong family support. They were there throughout the trial. They desperately want him to receive mental health treatment. So we suggest, Your Honor, that the minimum
How long has he been in already? Since 16, right?
Yes. Well, since 15 is when the case is. So he's been in a long time, And this is just going to, if anything, aggravate his mental illness. He needs treatment. As I said, he has a very minor criminal record, criminal mischief in the 4th degree for a 44-year-old man. It's a very minor history. And I think the sentencing, I shouldn't say I think, but it appears that the sentencing court felt, this man's crazy, don't let him out on the street. Let's lock him up.
Okay, thank you. Ya tiene 6 adentro. Yeah. Yeah. People versus Joseph.
Give the prosecutor some time.
Ready?
Good
Go ahead,
afternoon, Your Honors. Lorca Morello for Appellant Ronell Joseph. The people's entire case was based on the complainant's testimony that my client took his chain from his neck by force. Now, the jury acquitted Mr. Joseph.
On the robbery count, right?
Yes, of 3rd-degree robbery, which the elements of 3rd-degree robbery are stealing by force or threat of force. Therefore, the acquittal was necessarily a finding by the jury that no force was involved in the taking of this chain. Now, under the circumstances of this case, the acquittal of the Rob 3 charge left no reasonable view of the evidence that would support
But
the
counsel,
charge.
I'm a little confused. You need force for grand larceny, which is what he was convicted of. Is force a required element for grand larceny?
Force is not an element of grand
So
larceny.
why would finding that there was no force in any way be inconsistent with a jury finding him guilty of grand larceny?
Because because the people have to put in evidence giving rise to a reasonable inference that the chain was taken by some means other than force. Chain was taken from the complainant's
Why
person.
couldn't the jury find that? Why wasn't there evidence that the chain was taken, but that it wasn't necessarily the use of force in taking of it?
But there is no evidence. There was no evidence that the chain could have been taken in any other way. And the people actually concede this in their brief. In their argument, they over and over say that this was a chain snatching. The evidence demonstrated that defendant snatched the chain off Jeffrey's neck, screaming, "God forgive me."
Well, he lifted the chain off his neck.
Lifting the
And
chain
Jeffrey
is...
did not struggle with him, so he took it off.
No.
Now,
No, that's not right. Lifting a chain from someone's
I
neck
was
is
quoting.
not grand larceny. You can lift a chain from your wife's neck. You will not be committing grand larceny. Lifting a chain, stealing a chain from somebody's
Counsel, there's
neck.
ample testimony that would support a finding that he took it from him without his consent, even if it was not by force.
The only testimony was that it was taken by force. And again, the people concede this in their own brief by saying this was a chain snatching. A chain snatching is necessarily a forcible taking. That is Rivera, which from this court, which is cited in my reply brief, but you don't even need a case. If somebody takes a chain from your neck saying, "God forgive me what I'm about to do," and makes you so terrified that you can't resist, that is force. The people also, this whole argument by the people just, ignores that there was an acquittal, which means that no force was used. They also
Not necessarily. Juries acquit for all kinds of reasons. And they very well may have decided to split the baby in half and not convict on the robbery and convict on the grand larceny because these two knew each other.
An acquittal is an acquittal. You cannot go behind the acquittal and say, oh, but this was, this
Well,
was.
you're doing exactly that.
You doing it.
You're doing exactly that.
No, I am not. I am saying there was zero evidence that would support a finding, a rational finding, that this chain was taken by any means other than force. The people did not present any such testimony. They didn't even present a theory, and they don't even present a theory on appeal. They just keep saying this was a chain snatching. Well, a chain snatching is the
So
use
you're
of
saying
force.
that the evidence here, it should have been robbery, it should have been third-degree robbery, and therefore it would nullify the grand larceny. Is that what you're saying? Because you're saying that it was by force, right?
There was no force.
But you're saying
Right.
There was no force or threat of force.
But Jeffrey agrees, right? Jeffrey testifies, and page 20, 21, 20 to 21, and page 21, he says that talks about the gun, etc. He did not give the chain to defendant. So with the gun to Jeffrey's side, defendant snatched is the word that he used from Jeffrey's neck, and told Jeffrey to give him the cash in his pocket. ID 20 to 21. And then here, Jeffrey testified that the defendant lifted the chain off his neck.
Lifted the chain with a gun in his stomach, which the jury rejected. They rejected the gun, right? Because if they had found, as the people keep saying in their brief, that it was a chain snatching, screaming, "God forgive me," and in fear and did not resist. If they had believed that story, they would have convicted him of rob 3. They would.
Well, maybe they ignore that and follow Jeffrey's testimony that said that Jeffrey did not struggle with him, so he took it off.
Took it off with a gun in his side. You like that Huxley quote? You know, facts don't go away because you ignore them.
Okay.
And that's what's going on here. Thank you.
Thank you.
Good afternoon. May it please the court. Diana Lewis for the respondent. As your honors know, there is no force necessary for 4th-degree grand larceny.
correct me if I'm wrong. Maybe I'm not understanding the argument that the appellant was raising, but I think she's trying to say that because there was an acquittal of the third-degree robbery, there could not be a conviction on the grand larceny.
Which is totally
I think that's what I'm hearing, unless I'm hearing it wrong.
I believe that's what they're saying,
right?
But I think there's an error.
Because of the way I'm hearing the argument is that the jury rejected the armed robbery, like, you know, with a weapon, you know, the third degree. So therefore, there was no force at all, which means then the grand larceny, I guess they're trying to argue is a lesser included offense, and that's got to go too.
Correct. Grand larceny, though, is not a lesser included.
I'm just trying to understand the argument.
Grand larceny required force?
No.
Oh, right.
Which is why one theory that they found, in as much as they found that no force was used, because only the chain was lifted without struggle, they found, okay, that doesn't rise to robbery, but it does to grand larceny because there was no force used.
Correct.
And we're all speculating. We don't know what the jury did.
And it's improper to speculate into the deliberative process of the jury. Unless your honors have any further questions for me, I'll rely on my papers.
I think we're good.
Thank you.
We'll give the rest of the time to your opponent. Because she has issues without question.
I think you are not understanding that Rob 3 is use or threat of force. It is not armed robbery. When the jury found no use or threat of force, they were not believing what the complainant
Yes, I got that. They acquitted him of third-degree robbery, which means that they did not find that there was any use of force with respect to the incident, correct? That's what you're saying, unless I'm saying this wrong. That's what you just said, right?
Yes, that's correct.
And you're saying because of that acquittal, the grand larceny has to go down too.
Yes, because...
Why?
Because the grand larceny that he was charged with requires a taking from the person.
Yes.
There's no way,
A taking without the use of force.
it doesn't,
Does a taking require force?
yeah, well, stealing, it requires stealing.
No,
I mean,
but
just
if you look
lifting
at
a
Jeffrey's
chain doesn't,
I mean, Jeffrey is saying, listen, I didn't struggle. The guy just lifted the chain. I mean, like I would take a set of pearls from my wife since you used her before. You know, that's lifting something doesn't mean that I'm using force.
yes, but you didn't have a gun to your wife's side
Why
when you were
can't
doing
the
that.
jury accept some portions of the testimony and not others? Find that he did not consent to the chain being taken, but that he was not intimidated by the gun, or that he didn't sufficiently establish there was a gun involved, but that he did take it without his consent, which would satisfy the requirements.
No.
That goes to your explanation of why the grand larceny falls. Tell us why.
Because the way this complainant testified, and I don't know why you keep saying that he just lifted the chain off. He did not just say he lifted the chain off. He said he lifted the chain off with a gun to his stomach, saying, God forgive me, what I'm, et cetera, that he was too terrified to resist. That's in the people's brief. That's what they keep saying over and over. This was a chain snatching, a violent chain snatching that made the complainant
You haven't
too
explained to me,
terrified
you
to
haven't
resist.
told me why the grand larceny charge should have been dropped, because the third degree robbery, he got acquitted on third degree robbery. How does that affect the grand larceny charge?
Because they have to present evidence whereby a jury can find that the chain was taken from the person of the complainant by some means other than force. There is no ground except, speculation about mercy, which really is total speculation. And even if it was mercy, it's still an acquittal. It's still a finding that the people had not proved beyond a reasonable doubt that any force was used in this incident. And that's why it cannot support grand larceny. And I refer you to Robert YY, which is quoted in my brief. It's absolutely identical. The complainant said, he threatened me with a shotgun and I gave him $5. The jury didn't believe anything about the shotgun. There was no way other than the threat with the gun to support a finding of larceny from the person.
All right, thank you.
Thank you.
Thank you both. Okay, Werther versus Werther.
Good afternoon, Your Honors. Annette Hesapidis, appearing for the plaintiff's appellants. The lower court respectfully erred in ruling in this case that there were questions of fact. The court ruled that the timing of the submission requirement was not designed to thwart the intent of the IRA holder. That is not, with all due respect, that's not the correct analysis of the law under the substantial compliance doctrine, and I'd refer the court to Connecticut General Life and Durkin, which Judge Acosta, you wrote on that case. The decedent, or the evidence has to show that there was substantial compliance by the decedent, and also in this case, the agent, doing all that was reasonably possible.
Why do we care about the intent of the decedent? There's no question at the time the change was executed, there was a valid power of attorney by which it was executed. So that's the person whose intent we look at, because that's the person who executed the change. The only real challenge you have is that she didn't submit it until after the death of the decedent. So what does that have to do with whether or not there's substantial compliance with the requirements of where the IRA is as to whether or not it was complied with?
Intent is not actually what's relevant here, and that's what the lower court got wrong. Under McCarthy—
Whose intent?
The decedent's intent.
Why is the decedent's intent relevant if, again, the decedent is not the one who executed the change? The person who executed the change with valid authority was the defendant.
That's correct.
So why aren't we looking at what the defendant's intent was at the time she submitted the change of beneficiary form, since it's her intent, since she was the one who executed it?
Well, I would submit to you it's the defendant's actions, not the defendant's intent that we look at. And it's very interesting that you raise that point, because this case is unusual, because Ellen's argument on this appeal is that the only thing that's relevant is whether Dr. Werther undertook affirmative actions before he passed to change the designation. If you look at her brief at
She
page...
wasn't the one who changed it. She was the one who changed it, and she had the authority to do so.
That's correct. And in fact, Dr. Werther signed the trust agreement on the same day that she signed this change form. And I'm pointing out, Your Honor, that Ellen's position is that her actions are irrelevant. Our position is that her actions are indeed relevant, because mere intent is not enough to prove substantial compliance.
How does her delay in submitting the change in beneficiary designation, so after her death, his death, reflect her lack of intent to effectuate the change that she clearly had the authority to perform?
Well, it's the fact that there is absolutely no evidence on this record as to why there was a delay, frankly.
But why do we care? If she had the authority to execute it, and there's no question she did with the power of attorney, why do we care whether she delayed till after his death or not?
Because we're talking about financial transactions. Morgan Stanley had a document on file that designated the children as equal beneficiaries. In order to set that aside, it's a binding document. In order to set that aside, substantial compliance is required. And
right, so what about the way she did it after the death? How do you establish that the fact that she did it after the decedent passed away showed lack of substantial compliance? What about the rules of Morgan Stanley prohibited her from submitting it after the decedent's death?
Well, under the substantial compliance doctrine, it's not about the rules of Morgan Stanley. It is what affirmative acts were undertaken.
Let me just say, in all of the cases that are the precedent that everybody's looking at, those are cases where the question really was what the decedent did or did not do. They did not involve power of attorneys, where there really was no issue whether the person who executed had the authority to execute the change. Those are ones where the decedent might have changed his mind or her mind, but didn't submit it, and it was not submitted until after death.
But that's the point here. The agent was obligated under the power of attorney to act in furtherance of the decedent's best wishes. The fact that she did not submit it and has not explained to this court through any evidence why she did not submit it for over a year is evidence that she satisfied her fiduciary obligation.
If your father dies and she's the one who's handling everything for him, I can see why. I mean, the difficulty that I have is you have an original distribution of the RRA, which basically what, gives them 1/3 each of the siblings?
Yes.
So you're talking about Ellen, right? I mean, you want a finding as a matter of law that regarding the decedent's father's intent, right? You want us to find as a matter of law that either it was wrong or it was right.
No.
How do we do that as a matter of law? Isn't that for the court?
No, with all due respect, Your Honor, we do not want a finding as a matter of law as to decedent's intent. We want a determination that on this record there has been no affirmative act by the decedent or his agent between 2017.
I thought Supreme Court denied plaintiff's summary judgment.
That's correct.
Right, ruling that the 3 siblings are not the trust and the rightful beneficiaries of the RRA. And then granted the defendant's cross motion, right?
For leave to amend.
Right.
That's correct. I see my time is up. Did you?
No, I'll give you an extra 30 seconds. I took a lot of you.
So the point here is that she's argued that discovery is needed to establish the decedent's intent. The court has rejected any claim that the lapse of time between when the form was executed and her submission of it is irrelevant to intent. In her briefs and in this record, Ellen has never once indicated that the discovery will explain why there was this delay. She was his fiduciary. If she had proffered an affidavit saying, I forgot about this form. Yes, I signed this on the same date that my father signed the trust agreement, and I misplaced this form, and I only discovered it after his death, I wouldn't be here. But she has not even indicated that discovery is required to show this. She's indicated that under 3212F, excuse me, that discovery is needed to prove his intent. For substantial compliance, it is not intent. It is what actions, why were the actions thwarted during the life of Dr. Werther and during Ellen's time as his fiduciary that prevented her from executing it. So if you send this back for discovery, there won't be any. She's admitted in her brief, I'd ask the court to look at page 126, and which shows that the discovery is only towards intent. She is never going to explain why she did nothing.
Okay.
Thank you.
So counsel is going to tell us what the discovery is if we remand this case back.
Your Honor, I'd like to note for the record that it's the first time I'm in a courtroom since March of 2020, and I am delighted to be here.
Thank you, counsel. We are too.
No, it's been way too long. Your Honor, I think that as the questioning from the two justices here, the problem here arises from the fact that the plaintiffs are confused about the applicable law. As Justice Crane explained in her decision, which is the basis of the appeal, the plaintiffs are conflating the designation of IRA beneficiary, which has to obviously be signed by the person making the bequest before he dies, and that where Morgan Stanley has released the funds, as they have here, the only requirement is substantial compliance, and tendering is a different issue, and so long as it is substantial compliance, and that obviously is, there are issues there that raise issues of fact, so long as that is reasonable, then they've complied, then everything has been complied with, and the designation stands.
They just want to know the simple question. I think, from what I hear, the argument is that the issue for them is they want to know what was her delay. Why did she delay from the time she filled out the form to after the decedent's death that she now wants to submit the form, which Supreme Court said she couldn't do because this action prevents that form from being submitted. It's just that there's just that gap in time that they just want to know. And counsel even said, if she had just said in the affidavit, I totally forgot about it.
Mm-hmm.
She said, counsel just said, we wouldn't be here right now.
I agree. And if the plaintiffs had decided to make this motion after discovery, i.e. after the deposition of Ellen Werther, she would have said, I had the thing signed before. I didn't realize I had to do it until he died. And as soon as I realized it, I submitted it.
What do you need a deposition for? You just put an affidavit in. Why do you need a deposition for that when you could just put an affidavit saying, look, I forgot.
There are other issues. No, there are
like
other
the
factual
PJ said,
issues.
the daughter's doing all the work for the father. I mean, there are things that are going on. There's a lot of stuff going on when you're trying to live two lives that, it's simple matter of fact that she may have forgotten. It could have been simple, right?
It's that simple, Judge. Believe me, if
why are we here?
do it over again, she would have done it before.
So, counsel, how did she substantially comply?
I'm sorry.
How did she substantially comply?
How she substantially complied? She had a writing signed by her father, Dr. Werther, and
before he died.
Before he died, of course, because we wouldn't be here otherwise. Before he died, she should have, but did not, submit that before. There's also evidence in the record from Dr. Werther's friend and his physician, Dr. Way, who indicates that Dr. Werther was debilitated, he was 90 years old, and he was in a wheelchair, so he couldn't do it. He couldn't go down to the place where he had to submit this form. He couldn't send it to the post office, and he relied on his attorney and his attorney in fact, and they didn't do it. And they didn't do it because they didn't realize they had to do it. They had it. After he died, they realized they had to do it, and they did it. understand that he died on October 18th. By November 1, 12 days later, they submit the form. So there's no delay.
Do you think any discovery is required, or do you think you can make out?
I'm sorry?
Do you think any discovery is required, or do you think that you're entitled right now to judgment based on showing?
Absolutely. I believe that if you look at the record evidence here, what do we have? We have a power of attorney from October 2017, which is valid to designate beneficiaries. We have the designation of IRA from October 3rd, 2017, the same day. We have the tender 12 days after, on November 1st, 2018. And the only thing that plaintiffs bring up is the fact that there was a prior power of attorney with a prior designation. But as we've made clear, that prior power of attorney was legally insufficient to make that designation. And the plaintiffs try to ignore that or run away from it, but if you take that away, they have nothing. And we have complied with everything. And the motion should have been granted in favor of defendants. We shouldn't be here. And, you know, there is so much confusion in this case because obviously this is a family affair. And the two siblings represented by plaintiffs, Stephen was written out of the will, so he has nothing to lose by contesting. His sister, Jean, is a 1/3 beneficiary. What she's complaining about is not that she won't get her 1/3. She has issues in her life, and her father asked Ellen to establish a trust for her and take care of her. And despite all of this disgusting litigation, Ellen is doing that. So Jean is really fighting for what she already has. Ridiculous.
Thank you, counsel.
That's the way it is. Thank you very much.
Thank you.
So, you know, I have a question to ask. My question is very straightforward. You're saying that I need to know why Ellen waited so long to file or to finally file this form with Morgan Stanley, right?
That's
the time it was, we're not disputing that she had the authority at the time to execute this form. Because
Not disputing that.
Okay, so now the question is between the time of execution and the actual time that she wants to file the form.
That's correct.
You want discovery and you want to figure out what the intent is.
I don't need discovery. She was an agent. She was acting as his agent under the power of attorney. The fact that she didn't present it during his lifetime is evidence that it was not his wishes that she presented.
No.
Why? She's his fiduciary.
Why do you reach that conclusion? She's a daughter taking care of her father and is obviously upset, but I understand that it was filed 11 days later.
No, with all due respect, we're confusing the dates because they're all in the same month.
You're saying that because you're saying that she completed the form when the decedent was alive. She has absolute authority to do that. You're saying because she didn't file it, that's going to be evidence that she didn't, that there was going to be no change in the beneficiary, right? That's what you're saying.
Yes, because substantial compliance under Connecticut.
Yeah, but you know, but you're ignoring the fact that she had total authority under the power of attorney to do that regardless.
She had authority to execute it, but
Yes.
the issue, Judge Acosta, if I may refer to Judge Acosta's case of Durkin. In Durkin, the decedent had handwritten her change of beneficiary designation form by hand with the financial advisor on the phone walking her through it, and then she sends it to Morgan Stanley, but she forgets to sign it. Morgan Stanley accepts it as sufficient.
How is that evidence of the father's intent?
If I may, this court held that that was insufficient. She signed it in her own hand. The financial advisors literally walked her through completing the form. She presents it, and it's not signed. And this court held that that was insufficient proof of substantial compliance because...
Counsel, that case involved the decedent's intent. There was no power of attorney in that case. Once you give someone a power of attorney, and this is specifically a power of attorney to make IRA beneficiary designations, then you have to look at the intent of the person with the power of attorney, not the intent anymore. So I don't understand how those cases are applicable, Because those are cases where it was clearly the decedent making the change in beneficiary designation, and then the decedent died. Here, it's the person who had the power of attorney making it, and she's still alive to say, yes, I signed it and I submitted it.
Well, if I may then we're going to be creating two different lines of cases here.
I don't think so.
Well, where an agent can hold on to that form
I mean, if
for
it was
5
my
years.
case, I can always say I was wrong and then
No,
just.
no, if I may, I see my time's up, but we're going to have two different lines of authority here for substantial compliance. If the agent completes the form, the agent can hold on to that form for 5 years and then present it, and that's okay because the agent is still alive and they had the authority to execute the form at the time. But in cases like Durkin and Connecticut General Life, if it's only the decedent who signs the form but forgets to submit it in the couple of years before they die, that's not substantial compliance. And with all due respect, I believe you're creating a divide in the precedent that's unwarranted. Thank you.
Thank you. Thank you both. Monitronics International. Larry Marks keeps calling me. Let me see what the hell is going on.
Good afternoon, Your Honors. My name is John Curley. With the court's permission, I'd like to introduce Matthew Evans and ask his permission to argue the case on behalf of the
Yeah. Application is granted.
Thank you, Your Honor.
Your Honor, Matt Evans on behalf of the appellant, North Star Alarm Services. This is an appeal from a partial summary judgment motion. There are two issues, and even in the appellee's brief, they identified the two issues in this way, and I'll go with the way they identify them. In the first issue, they raised the issue of did the trial court err in granting summary judgment dismissing North Star's first and second counterclaims, each of which alleged that Monitronics breached the parties' agreement by imposing the cost recovery fee. I don't think we have a dispute that just imposing the cost recovery fee as they did in these alarm services contracts that we sold to them, that is a breach. In our position, there was a bit of an ambiguity as the court's ruling. Our position is that by imposing the cost recovery fee,
I get it. They imposed the recovery fee. They credit back the recovery fee to the customers, but then they didn't credit you. They charged you when they sold it back to you. You had to pay the higher amount of money, correct?
well, sort of, but yeah, I mean, they're
Well, it's either
giving
yes
us
or
back
no.
those contracts,
Right.
and now they've changed the pricing on them.
Right.
Now,
So-
why isn't this covered by the fourth counterclaim? This is exactly what you allege in the fourth counterclaim. The fourth counterclaim has not been dismissed, and any claim that you're making would be clearly covered by the fourth counterclaim as opposed to the first and second, because as you said, it's not just the imposition of the cost recovery fee that you're objecting to. You're objecting to it because it's an improperly inflated chargeback, which you have a claim for, and that still exists, so I'm not sure why you care.
Yeah,
First and
and
second
we
counterclaim is
stipulate that if that's the case and we can proceed on the fourth counterclaim, Your Honor.
Well, it wasn't dismissed, right?
No, it was not.
So you're going forward on it.
Yes, and I think our fourth counterclaim from our position is it's even broader than simply that they imposed the cost recovery fee, that they didn't meet the elements of charging back as well.
That's
And we want to
fine,
bring.
then you don't need your first and second counterclaim because they're really encompassed within your fourth, and I think that was the reasoning of the court, that these are not really standalone counterclaims, they're encompassed in the fourth counterclaim.
Right, and as long as that's the case, we're fine. I would just address the second issue, which I think is really important, this tortious interference with contract. Your Honors, we have, as we cited in our brief, there is.
Let me ask you about that, because what contract was tortured? You don't have a contract anymore with those customers. Your real dispute now is, again, the improperly inflated chargebacks to you vis-a-vis you and the other party. There are no customers anymore that you have because you gave those customers away, so how can there be tortious interference?
I respectfully disagree that we didn't have a contract. We still had those customer contracts, and we've identified them at page 8 of our brief. We had the contract with the customer. That contract did not allow any change in cost structure. So we sold that contract to Monitronics, but we're still the signatories on that contract.
Yeah, but you sold it. You don't have the contract anymore.
But we do, respectfully, when what would happen if the customer had a problem and sued, They would sue us, and then we would seek indemnification or something from Monotronics. So we still had that contractual relationship. Now, it doesn't cause damage to us until Monotronics says, you got to take those back, and we're gonna charge you $2,000.
Isn't this a hypothetical counterclaim?
Sorry?
If there's no damage yet, it's just a possibility of damage, how is there a viable claim?
Well, once the contract comes back to us in them saying, hey, we're sending this back to you, because this is a bad contract. Well, it's a bad contract because you increased the cost on it, probably. That's our argument. Once that happens, then we have damage, because now we have a contract that's no longer paying, Your Honor, that they've interfered with the terms of the contract by imposing the cost recovery.
Which term of the contract? Where does it say that they cannot impose that
Well,
fee?
as we've cited in our brief, it talks about the terms and conditions. The customer contract refers to the terms and condition, talks about the pricing and everything else, and contains no provision that allows for us to increase the cost. So by increasing the cost, you are breaching the terms and conditions of the agreement itself. And so what we're saying is all of the elements of tortious interference exist here. There's an existence of a valid contract. We've always been parties to that contract. Their act in imposing the cost recovery fee interferes with that contract, and we've been damaged thereby, because now this customer's not paying anymore because you've interfered with the relationship by increasing the cost. So that would be our position. We would say that the lower court erred by making this, the conclusion that we didn't have a contract, and that we were strangers to that contract. No, we were always obligated on the contract. We had simply sold it.
So you don't need to wait for their determination that it's a bad contract in order to trigger your involvement once again.
Yeah, I mean, one of the provisions in the contract, 2.02 of the AMPA, actually indicates that we had warranty obligations even after we sold it to Monotronics.
Okay.
And so we were still parties to that contract. We still had obligations to our customers. And once we get it back, well then, that obligation, it's our contract. It's always been our contract, but once we get it back, then it's an active contract that we don't have rights to go after them and say, you need to deal with this.
Okay, thank you.
Good afternoon, Your Honors. Nicole Meyer for the respondent. I'd like to introduce David Brenton Vacate. He's been admitted pro hoc in connection with this appeal and respectfully requests that he be allowed to participate.
Yeah, you can find New Yorkers to come and, we admit about 128,000 lawyers, Go ahead. Application is granted, counsel.
Thank you, Your Honor. Brent Vacate on behalf of the respondent. I believe what we just heard is the counts 1 and 2. Those are kind of subsumed within count 4. I think we can agree to that. As it relates to the tortious interference claim, I think the main point here is pretty straightforward, is that a party cannot interfere, or someone cannot interfere with a contract that it is not a party to. Here, North Star very clearly in the AMPA.
Why is he wrong when he says he's still a party to the contract?
He's wrong because of this. In the record at page 79, Exhibit B, the form bill of sale, specifically states that the customer contracts, once we acquire them, that North Star relinquished, and this is a quote, all rights, title, and interest. There's nothing else left to talk about with respect to...
But they say they have warranty responsibilities and they have all their involvement with the contract once you determine the contracts to be bad contracts.
Sure, they may have some warranties, as it relates to perhaps equipment and things of that nature, but they're no longer, as a result of signing the AMPA and providing that bill of form, they're no longer have any, and it's quote, all interest, title, or rights in any of those contracts. That's very clear.
So the contract becomes a contract between you and the third-party customer, right?
That's exactly correct. So,
and under the agreement of you have to, the return of bad contracts, it's at that point that the contract then reverts back to them.
that's correct. Yes, we would return those back. That's correct.
So is it your position that only until that happens does the defendant have a contractual stake in the action.
Correct. To the extent that that's correct. And I think also as the trial court found, there's no allegation and certainly no evidence that Monotronics interfered with those customer contracts once we provided them back. So that's all I have for the court, unless you have any questions.
No, I think we're good. Thank you.
Your Honors, I'll be brief. While we did sell them the contract, we don't dispute that, and we sold them all rights and title and interest to the contract, they didn't sign a new contract with the customers. The customers are still a contract that they signed with North Star. So the contract with the customer still exists.
Right, so the contract governs, and the question that I have is, why is it a violation of the contract for them to impose a fee to the customer?
Because the only contract that is with the customer at this point, we've sold them the contract, but the only contract that is with the customer is between us and the customer. So while they have the rights and interests in that contract, we also have obligations. I'll use the best example. So there's something goes wrong with this contract. The customer doesn't sue Monotronics because on a contract claim because they don't have a contract with Monotronics. They have it with us. So yes, you impose a cost recovery fee when the contract doesn't allow it because there are terms and conditions as to pricing. So then you have this contract, and then you say they stop paying.
Counsel, has anyone sued you? Has anyone sued your client?
I'm not sure, to be honest with you. What we could have done if they would have kept the contract is we could have said, hey, if someone came to us and said, we got a problem, we say, go to Monotronics, because we have indemnification provisions under common law and under the contract. But the contract still exists, is what I'm trying to say. And so because it still exists, there is a contract between us that they interfered with by implementing the cost recovery fee.
Thank you. Thank you both. Schnell Contracting. Okay.
Good afternoon, Your Honors. May it please the Court. Andrew Akron on behalf of the appellants Empire Outlet Builders, LLC, and St. George Outlet Development, LLC. This appeal stems from the denial of a motion to dismiss regarding two claims of alter ego. And what plaintiff is seeking here, the respondent is seeking here, is to pierce both the corporate veil of Empire Outlet's Builders to hold St. George Outlet Development responsible for Empire Outlet's liability on a contract, and pierce St. George's corporate veil to hold Empire Outlets responsible for St. George's responsibility on a mechanics lien. What the complaint fails to do, however, is allege in anything but conclusory fashion that either Empire Outlets controlled and dominated St. George, or that St. George controlled and dominated Empire Outlet.
I thought they did, both with respect to control and domination, basically by the same owners, same officers, and managers. So what's conclusory about some of the very specific things that they have alleged?
The specific things that they've alleged is that the owners controlled both. But they don't allege that St. George controlled Empire. They're a separate corporation. They're not run the same. They have
Corporations are run by people. Corporations don't run themselves, okay?
Yes.
So let's cut right through the chase here. You've got three people who are interconnected on all sides of this. They do not at all, they share all of the same corporate form, the same offices, everything.
They're organized separately, and actually the
Of course they're organized separately.
They're organized separately.
But they live together.
Yeah.
The three individuals are not actually even the only members of the corporations, nor is, in one case, an individual, even a member of the corporations. Mr. Kaposha is not a member of either of the LLCs, as alleged. Perhaps there is an allegation here that the individuals controlled and dominated, but that does not mean that the sister corporation also controlled and dominated. It would be one thing if plaintiff were asserting that an alter ego allegation or an alter ego claim could be asserted against the individuals. It's completely different to assert that the sister corporation has domination.
Counsel, has discovery been done in this case? This is a 3211 motion, isn't it?
This is a 3211 motion.
So they're going to get an
Discovery is
opportunity to depose and determine the exact role of each of the individual members vis-a-vis the corporation, right? All they need to do is sufficiently allege the Morris factor, right?
Yes, Your Honor, but it's in particular in Morris, where the corporation is not even a shareholder of the other corporation. Morris said there cannot be an alter ego or piercing claim against an individual who is not a shareholder. And St. George is not a shareholder of Empire Outlets.
Well, but St. George received $284,000 as part of the whole, that was supposed to be used for the plaintiff itself.
No, Your Honor. This deals with a massive construction project. The money that was received was for payment of the...
I understand. The $284,000,
284 million.
The money, right, and some of the money that DASNY and ESD and Goldman Sachs gave was supposed to be used for the payment of labor and materials on the project, right?
Yes, Your Honor.
Isn't that what they're alleging?
They're alleging that the money was supposed to be used, and that it is alleged, though it is not accurate, that St. George withheld
Well, we'll
money
see
from-
after discovery, right? That's the whole point.
Well, the allegation is that money was withheld from Empire Outlets, but what is not alleged is that Empire Outlets was rendered judgment-proof as required by this court in very recent decisions. So Empire Outlets is not alleged to be judgment-proof, and therefore the...
Counsel, we have no idea because no discovery has happened yet. So on a 3211, again, there certainly is sufficient facts pled to survive a 3211 motion.
Well, Your Honor, I understand what you're saying, and discovery is ongoing. However, this court has said that certain pleading requirements need to be met, and it is our position that they haven't been met. And included in that is that the pleading has to allege that the corporation for whom the corporate veil is sought to be pierced, it has been rendered judgment-proof. And that allegation is absent from this complaint. And without that allegation, this court has said a veil-piercing claim should not proceed. And that is our assertion here, that the allegations here do not allege that St. George controlled and dominated Empire Outlets, does not allege that Empire Outlets was rendered judgment-proof.
Well,
Counsel, if I
but
may.
you only raised that now, right?
Yes, we raised that for the first time on appeal. However, this court can consider matters of law that are determinative, even if raised for the first time on appeal.
Counsel, if
would
I
be
may,
that.
these arguments about being judgment-proof, actually, they are contradicted. And I'm looking at the amended complaint, paragraphs 51, 52, and 68. Set it forth about...
If I may respond.
Go ahead.
The allegations assert that Empire Outlet was rendered insolvent. Insolvency has a very specific legal definition. It means that they are unable to pay their liabilities. That does not mean, however, that they're judgment-proof. It is not alleged that Empire Outlets has zero assets.
Okay, all right. Thank you, counsel.
Thank you.
Good afternoon. May it please the court. My name is John Harris. I'm counsel for plaintiff respondent Chanel Contracting. You just heard appellant's counsel argue that the amended complaint is devoid of any allegations that the corporate defendants in this action have common control and dominion, and that that common control and dominion was used to wrong respondent. Well, in the complaint, there are 37 paragraphs that allege these particularized facts that the appellants simply ignore in their brief and in their argument today. And we actually identify them specifically by dashes in respondent's brief on pages 18 through 21. And appellants ignore all of those particularized factual allegations in their appeal. And in the first department, there are a number of ways. There's no one particular way to adequately plead a piercing the corporate veil claim. In our brief, we highlight two of them on respondent's briefs, page 13 through 14. There are two cases that we focus on. First is Colby Partners LP versus GSC Capital Corp. And in that case, they say that if two corporations are controlled by the same people, such that one corporation causes one entity, the other entity, to breach a contractual obligation for personal gain, well, that's certainly a misuse of the corporate form that suffices to plead an allegation here. And also in Baby Fat Holding Co., we have a holding from this department that an allegation and complaint that states that corporate funds were purposely diverted to make an entity judgment proof to work a wrong on the plaintiff, that would also be sufficient. And under each of these examples, the plaintiff appellants in their amended complaint have met those standards. Specifically, Brendan Barron, Joseph Ferrara, Donald Kaposha, the individual defendants in this case, owned the appellants. They created development to receive all the funds, the $284 million that Your Honor referenced before, and they created Builder to be encumbered with all of the liabilities to subcontractors on the project, including Respondent. And then the individual defendants, using their common control over both corporate defendants, essentially withheld money that was supposed to go to Builder for the subcontractors and kept it in development and for their own personal gain. And we allege this specifically in paragraphs, I believe, 41 through 52, an instance where Donald Kaposha negotiates with Respondent, saying that, where he negotiates both as a principal of development and a principal of Builder, saying development has the money to do this, but it's got to pass through Builder to do it. Next day, Builder still doesn't have any money, but meanwhile, as we allege in the complaint, development keeps the $284 million. And under Colby Partners and Baby Fat Holding, that's sufficient at this pleading stage to allege a piercing the corporate veil claim. So if you have any other questions, I'm happy to answer.
I think we're good. Thank you.
Thank you, Your Honor.
Your Honors, if I may just quickly, the allegations pointed to by Respondent's Counsel and which were noted previously by Your Honors address only the individuals. The individuals who are no longer defendants in this case were never alleged to have domination and control. No alter ego, no veil-piercing claim was ever asserted against the individual defendants. This is a case where the respondent is seeking to pierce the corporate veil of a sister corporation, and in doing so, fails to ever allege that the sister corporation had domination or control.
There was never piercing a corporate veil claim against the individual defendants?
No, there was not, Your Honor.
But there was against St. George.
There is a veil-piercing, I believe my time is
Go
up.
ahead.
if I may.
Go ahead.
The veil-piercing claim against St. George is restricted to the mechanics lien issue. Respondent filed a mechanics lien. They're seeking to enforce the mechanics lien and pierce St. George's corporate veil to make Empire Outlets responsible for that under a joint and several theory, which doesn't apply to a mechanics lien because that only applies to tort liens. The fact of the matter remains that there is no allegation that St. George exerted control over Empire Outlets, There was no allegation that Empire Outlets exerted control over St. George, and there is no allegation that either were left judgment-proof, as is required by this court, even at the pleading stage.
Thank you, counsel.
Thank you, Your Honor.
Thank you both.
No, he just won. Yeah.